For the next race, I introduce Justice Sam Ervin and Mr. Trey Allen. In this race, Justice Ervin is first on the ballot, so he'll have his 2-minute introduction. Then Mr. Allen will have his 2-minute introduction.
Thank you very much for having me this morning. It's a great privilege to see so many longtime friends in the audience and to have had some chance to spend some time with many of you over the last 24 hours. And I also appreciate y'all having this forum every election cycle because it gives us a chance to talk with you about the issues that are important. I want to talk really about two things today. First of all, I want to talk with you about my experience and how I got to the Supreme Court. I'm a native of Morganton. I grew up in Burke County. I'm a product of the Burke County Public Schools, of Davidson College, and of Harvard Law School. I practiced law in Morganton for almost 18 years, tried cases against at least one of you in the room that I can recall, tried numerous jury cases, handled many appeals, and represented all kinds of clients. I represented plaintiffs, I represented defendants, I represented individuals, I represented businesses. Basically, if you had a legal matter, my firm would be involved in it, and I would try to represent my client to the best that I could. The job of an Associate Justice of the Supreme Court of North Carolina is pretty simple. We're supposed to decide cases. We're not responsible primarily for running the judicial system. The Chief Justice gets that responsibility. He consults us from time to time, but we basically decide cases. My way of doing that's pretty simple. I look at the facts, I look at the law, and I try to make sure that I apply them fairly and dispassionately. I've been an appellate judge for 13 and a half years now. The members of this organization know what my record is. I'm a known quantity. You can make your own judgments about whether I've done a good job at the Court of Appeals or at the Supreme Court. But I believe my record shows that I work hard, that I study the record in the briefs, that I think independently, that I'm not afraid to vote however I think ought to be voted, and I appreciate the chance to be here with you today.
Mr. Allen.
I would bring a broad range of legal experience to the North Carolina Supreme Court. I serve now as the general counsel for our state's entire court system. My office gives legal guidance in civil and criminal cases to judges, clerks of court, and magistrates throughout North Carolina. I work for Chief Justice Newby. It's the second time I've done so. 17 years ago, I clerked for him when he was the newbie on the North Carolina Supreme Court. I'm also on leave from the UNC School of Government, where I'm a tenured professor and a scholar of North Carolina law with a particular focus on the liability of local governments and local government officials. I went to UNC from private practice in Raleigh, where I did civil defense work for school systems and school officials in state court and in federal court at the trial level and at the appellate level. So I know what it's like to be in your shoes. I began my legal career as a judge advocate in the United States Marine Corps. I want to do what one person can to restore the public's trust in our courts as institutions that make decisions based on the law, not on politics. I think we begin to restore that trust by selecting judges who are going to follow the Constitution and the laws we have, not the Constitution and the laws that they think we ought to have. I think that your clients and you want judges who are going to impartially apply the law to the facts and not put their thumb on the scales in favor of some preferred group or cause. I would be honored to have your support in my run for the Supreme Court. And remember, don't go astray, vote for Trey.
Judicial races have become increasingly partisan, and there is a perception that this is reflected in court decisions. By way of example, in February of 2022, the Supreme Court decided the Harper versus Hall case on redistricting in a 4-3 decision along partisan lines. how do you view the impact of partisan politics on the Supreme Court? Point to some examples where you have been willing to buck your party line. And we'll start with Judge Ervin for the first 4 minutes.
All right. Thank you for the question. Just so there is no misunderstanding, I am very concerned about the increasing partisanship of judicial elections. I am very concerned that the public loses confidence in the judicial system because members of courts are perceived, rightly or wrongly, to have a partisan or ideological agenda. I have no such agenda. I think my record shows that I do not have such an agenda, and I think that there are instances in which people can look at my record, which, as I said, is pretty extensive at this point, and see that that's not the case. I'm going to cite you 3 examples of cases in which people who, if they looked solely at my party registration, wouldn't have predicted the outcome, at least for my vote. The most recent one actually is one of the same cases that Judge Inman referred to earlier. About a year ago, the court, on appeal from the decision that Judge Inman described, held that the General Assembly and not the governor had the right to determine how federal grant money was spent. That case showed that a majority of the court, 6-1, concluded, even though 3 of us were not members of the governor's party, that we were not prepared to look beyond what we thought the law meant. Another example is one that I joined, and I think the court may have even been unanimous in this case, had to do with whether the General Assembly had the authority to require the gubernatorial appointees to cabinet positions be confirmed by the General Assembly. I voted, and I believe the rest of the court voted, to hold that the General Assembly did in fact have that authority, reserving the right to entertain as applied challenges in case there was a misuse of that authority. A third example that comes to my mind is one that I heard very early in my time at the Supreme Court, which had to do with legislation adopted by the General Assembly that divested the town of Boone of its authority to engage in extraterritorial zoning authority. That was challenged as violative of Article 2, Section 24 of the state constitution. And although I did not agree with the reasoning adopted by the majority of the court, I did vote to uphold the General Assembly's authority to enact such legislation. I have, on a number of occasions, voted exactly the contrary to what people would have predicted if all they knew about me was my political affiliation. So I think my record shows that I will, in fact, when I think it is appropriate, vote contrary to what people might expect if all that they knew was how I registered. I think it's important for courts to do that. I think that it is time for courts to stand up and point out that we do, in fact, do what we say we are going to do. Yes, some decisions do split on party lines, but many of them do not. And at least my record demonstrates that to the extent that I believe that people who are of my political persuasion are taking a position that is not the one that I believe to be correct, I have the courage of my convictions and will vote that way. I think that's what judges ought to do. That's what I promise you that I will continue to do. I will listen to everybody. I will make up my own mind, and I will decide the case based on what I think the law and the facts call for and nothing else.
I'm not a career politician. I've not been active in politics prior to running this race. But I do have a record. I have a record as a scholar at the UNC School of Government. Some of you may be familiar with the School of Government. It plays a huge role in especially local government and in our courts in North Carolina. Local government officials and judges turn to the school for nonpartisan information and opinions about the law. So while I was there in my 7 years at the school, I had occasion to write on a broad range of issues. Most of my scholarship is online, and I would invite you to look at it. And when you do, I think you will see the work of someone who approaches legal issues carefully and with a desire to get the law right. And I don't think you'll find even a hint of anything partisan in my work. And I would bring that same commitment to getting the law right and doing so without regard to politics on the North Carolina Supreme Court. As I said in my opening remarks, I think that we do. And I'll go a little further and say I think we actually have something of a crisis of confidence in our courts on the part of the public. So many people think that a judge's political persuasion controls the outcome in key cases. We really have to work to reverse that perception, and we will do that through opinions in constitutional cases that are based on the text and the history of the Constitution, something as objective as you can get in the law. And in cases involving statutory construction, on the text of statutes and on the legislative intent. No one, I think, who read any of my scholarship at the School of Government could guess what my party was. And my commitment to you is that if I make it to the Supreme Court of North Carolina, the same will be true in my opinions. They'll be as objective as I can make them and based on the law, not whatever my personal preferences are. I'm going to resist commenting on the Harper case. I will say, as a candidate who did have a primary, that the moving of the primary date certainly put me at a disadvantage. And the practical reality is, as a primary candidate, you have to spend money in the primary. And so moving that date does give your opponent an advantage if your opponent doesn't have a primary, because you have to start over raising money and the window of time is shorter. So I will be absolutely unbiased on the court. I will follow the law to the best of my ability without regard to political consequences.